car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome. You are watching another edition of The Attorneys. We are so glad to have you with us. I'm Wright Franklin, your host. Before we get started, I want to remind you about a number that you need to call. It is the right number to call if you have any legal questions. It's 1-844-LAW-TALK. That call is free. It is confidential. On the other end of the line, you will have an attorney from Hollis, Wright, and Clay, and they will answer your question right away. So go ahead and make that call right now. Now, we want to get started with the program we're talking about tonight is living trusts versus wills. I'm Art Franklin. That is Josh Wright right there. And our special guest today is Bobby Lott. And this is something that a lot of people have to deal with, and it's something I'm even having to deal with right now. Us included, right?
Exactly. We're not getting any younger.
No, we're not at all. But this is something that we want to unpack. Living trusts and wills.
You know, and so first of all, we're super excited to have Bobby on. He has been a guest host with us before on various topics. This is a skill set in his practice that he's really involved in and passionate about. And honestly, as baby boomers are getting older, these types of instruments become critically important and necessary. So first of all, welcome aboard and thank you for coming on and talking to us. Let's talk just a little bit about the concept. What's the difference, Bobby, between a living trust and a will, and kind of how did you get involved in this? Because obviously not every lawyer does this. So let's just kind of talk generally.
Basically, a will, as you probably know, is something that you create most of the time with an attorney, not always, but usually, to handle your affairs when you pass away, okay? It doesn't get filed anywhere. It's kept somewhere either with your attorney or perhaps at home in a safe, something like that, until you die. Nothing happens with it, okay? Then, when that happens, you have to open up an estate in probate court. Everybody's probably heard of dealing with probate. All right. A living trust, on the other hand, that takes effect the instant that you sign it and have it notarized, and it starts into effect right away. So if it's done correctly, you don't have to go through probate when you pass away. Your family won't miss a beat. Okay. And in the meantime, most of the time, you're typically the trustee or the one that handles it, manages it while you're alive. You handle your own affairs while you're still alive. And
you know, we've talked before in previous shows about the importance of helping with parents too as they're getting older and these types of instruments. This is a good show for that.
Yeah, you're talking about managing the assets and the distribution of those assets. And a lot of people, when they think about living trusts and wills, they think about those large assets. But you don't have to have a whole lot of money for this, right?
No, you don't, not at all. And that's a great question, because most of the time, like you said, when you hear the word trust, you think of people like Bill Gates and for us older folks, the Kennedy dynasty, the trust they have in place. But actually, that's not the case. You don't have to have a certain amount of money to set up a trust. It's very simple to do. The paperwork is very minimal. Most of the work comes into place at the front end. In other words, because you need to title your assets in the name of the trust. For example, like your house. An example might be you would move your house instead of in the name of Josh Wright. It might be in the living trust of Josh Wright and family. You can name the trust anything you want to, basically. So there's a little bit of legwork up front, which if you want to let your attorney do that, you can. It costs a little more money, but you can do it yourself, and they can help you do that too. So in other words, instead of with a will, your heirs spending their inheritance on taking care of probate and paying the attorneys and going through, most of the time it takes at least 18 months to settle an estate. All that's done up front.
So it sounds to me like you can create a trust, put assets in it during your lifetime, still use those assets, but then they instantaneously can be distributed at your death without having to go through the entire probate process that we'd normally go through in what we normally look at as kind of establishing an estate plan with a will.
Exactly.
Okay.
And that's one of the biggest upsides to a trust is you don't have to open up a case in court. You don't have to wait for a hearing. You don't have to do all the things that are involved with probating an estate. Now, I've done a lot of estates in probate, so it sounds like I'm shooting myself in the foot, but I'm not.
Yeah.
Because I've seen too many times where families are dealing with things that could have been dealt with while the person was still alive, and they're having to deal with this after they pass away, and it's not necessary.
This almost sounds like we've done shows on this where you have kind of an elective if you have a sickness and you don't want to be resuscitated, for example, you can create a kind of a living will. It kind of sounds a little bit like that. It just happens to deal with assets and distribution at the time of death.
Well, so what you can do, and that's true, in a living will or advance directive that handles your affairs while you're incapacitated in the hospital or something, you can combine all of those into your trust. In the trust, you can deal with your assets, you can deal with guardians for your kids, you can deal with advanced directives, living will, all that stuff can be combined into one document instead of all the 5 or 6 different moving parts involved with a probate estate.
I won't steal Bobby's thunder, but I know that he can come up with some examples of people who have passed away that did not have wills or estate plans that you'd be shocked at.
Yeah. That's a great point. And we all hear in the news and the stories about people. Most recently, Aretha Franklin had the issue with her will. She had a handwritten will stuck in her couch that wasn't signed or notarized. There was a big court battle over that. Michael Jackson, Prince passed away with no estate planning whatsoever. So,
what a mess.
Yeah, Anna Nicole Smith, I mean, the list goes on. Yeah. So the good thing about a living trust is all those estates, if they had a will, that's all public record. A trust is private totally. No one knows about it unless you tell them.
Well, one thing you were talking about, those famous people who did not have that in place. In the case of Aretha Franklin, there were several wills, including the one you spoke about in the sofa that they just recently found.
So there's a conflict.
Right. So how do you determine which one of those wills is a legal document?
That is where the courts come in, and you have long, expensive, lengthy court battles with testimony from relatives and people that knew her. So it can drag on for years.
Yeah, and you touched on something else, private versus public. You've got a messy situation going on in the family. Everyone's arguing over the assets and the distribution of those assets. Which one's private and which one's public?
The trust is private. Okay, a will, anybody can go down to the court and find out a will, excuse me, that's been opened and see who gets what. See, was Johnny named, he got half the estate. All that's public record. See, with the living trust, though, that's private. Nobody knows about that except the people you choose to tell about it. So whenever you pass away, whoever you named to handle your affairs and who gets your property, it happens without a beat.
I know we're getting ready to go to break. When we come back, Art, I want to talk and have Bobby explain a little bit about some examples of how you can put assets inside a trust and how they can be allocated at the time of death or even before death.
All right, so we'll go ahead and put a mark right there. Bobby, just stay put. We're going to go to break, but I want to remind you to follow us on all of the social media channels. All those platforms, you'll be able to get information from Hollis, Wright, and Clay throughout the week anytime you want those. And again, that number to call if you have any questions for any lawyer, a Hollis, Wright, Clay attorney is standing by right now. That number, 1-844-LAW-TALK. We're talking about living trusts and wills. We'll continue the discussion when we come back. Stay with us. We'll be right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys. We love this state and its great people. People that are worth fighting for in their lowest moments. It's what drives our lawyers to do what we do. We're here right now to fight for you. At Hollis Wright, your result matters.
And welcome back to The Attorneys. We are talking about estate planning tools, living trusts, and wills. And as we went to break, Josh, there was something that you wanted us to put a pin on so that we can come back to it so we can get into that discussion with Bobby Lott.
More than anything, I think it's helpful when we talk about concepts like that. It's easy for lawyers to be able to discuss a topic and understand it, but giving context to it to make sure that others understand it too, I think is important. And I want to kind of do that, and maybe the best way to do it is through an example of sorts of how would one put assets and resources inside a trust versus how they would be in the will if someone passed away. And I think just an example helps add some context where people are like, okay, hold on, that makes sense in my life. I could do something like that.
Yeah, it's a great question. And the most common examples are where, let's take one that's very common in Alabama. Let's say you have a home locally around Birmingham, and let's say you also have a condo in Panama City. Okay, it's two different states. Okay, if you have a will, and once you pass away, an ancillary estate is called, will have to be opened in Florida as well as Alabama. All right, so that hires another attorney, there's more paperwork, that's going to drag the process out further. Okay. Whereas in a trust, you can have property in multiple states and deal with every single one of those within the trust document itself and never have to fool with opening estates in those other states.
Makes complete sense. I mean, and that helps add some. Let's talk also, are there things that you can define in your trust during your lifetime, for example, that resources will be used for a nephew's education, those types of things? Can you add those in directly into the trust prior to passing?
Absolutely, and the great thing about doing that with a living trust, you're doing it while you're still here, so you can make sure that what you want to have happen actually happens. Mm-hmm. You're not depending on your heirs to go along with it. Now, most of the time they will, assuming you have a good family relationship, but occasionally, you know, things may have changed once you pass away and they say, look, I know this is what the will says, but I'm not doing that, or we can't do that. Mm-hmm. So if you have set the trust up properly, you can make sure that your wishes are carried out while you're still alive.
I think one of the things Bobby is highlighting, honestly, is the importance of having an estate plan one way or the other. You need to get to a lawyer like Bobby to be able to at least start to address what makes sense and what doesn't in your life.
And that makes sense. And someone is managing that living trust throughout the process. But here's a question for you, Bobby. What happens when that person who is managing that living trust becomes incapacitated?
Mm-hmm. That's dealt with in the trust document as well. You can put in there that if I, John Doe, trustee of this trust, become incapacitated, I hereby designate my son, daughter, cousin, neighbor, whoever, to take over as secondary trustee with all the rights, duties, et cetera, that I had when I was still capacitated. So any contingency can be dealt with within the document itself. You could put in there that you want your son or daughter to if they attend such and such school, they will get X number of dollars, or I'll pay all their tuition. The amount of variety that you could put into one is almost unlimited, as long as it's not illegal or against public policy. You can do it.
Sometimes people wait until the latter years of life before they start putting these things into place. When do you suggest that people start putting the living trust and the wills in place?
Ideally, the younger the better. Now, realistically, a lot of people starting out in their very first job may not really have anything, may not own a home, may own nothing but a car. That may not be the perfect time to do that, but if you're a young professional family with a couple of kids, just bought a house, that's the perfect time to do it. Because if you wait too long, then you have so many parts of your life you have to deal with, and your costs will be a lot greater at that point.
How do you, I know people have asked you this before, how do you determine when you're kind of assessing a estate plan whether a will or a living trust is a better option for someone?
Well, if you have either one is great. The worst situation is to not have anything. Yeah. If that happens, of course, then the state of Alabama determines who gets what. And it may be something completely contrary to your wishes, which you don't want to have. If you already have a will in place, you've had one for years, your circumstances have not really changed, it's probably not really necessary to change that. One reason you might want to do that is if you want to prevent your heirs from having to open an estate and pay the attorneys. You know, on average, the statisticians tell us that most probate estates will not close before a year and a half. Some sooner and some much later. Yeah. But a trust, you skip that whole process.
One of the things that we've talked about and Bobby just hit on is if you're doing a will, the process to set that will up, it can be efficient if you have a will, but the process takes time. For example, you've got to marshal assets together. You've got to put your creditors or the decedent's creditors on notice. You have to give them 6 months to give notice that they have a debt in the estate. So it can take a lot longer to do that. Yeah. And it sounds like the living trust can be kind of instantaneous at the time that you put that into place.
Absolutely. And that's really one of the best parts of it, is that you don't have to do all that. You don't have to have your executor, the person handling your will, doing all this, and marshaling assets, dealing with creditors. Yeah. And that can really drag out and get very expensive too. And
you know, I know that we get a lot of questions about, hey, if I pass away, and oftentimes, by the way, we may be doing a show on like a personal injury matter, but we'll still get questions about wills and estates. And it's because people are always questioning some of these issues. The question we get a lot is, hey, I have a home, and if I pass away, is that going to go to my spouse? And they probably have never read the fine print when they sign the documentation for that house as to whether or not that is going to become a beneficiary distribution or not, whether it's going to be a joint right of survivor or not. And so a lot of it comes down to the document itself. But you know, that's a good example of even when someone buys a house, they're not exactly sure what's in some of those documents. It's important to get to someone like you to be able to go through this.
Absolutely. And most of the time, married couples especially will have their houses joint tenancy. Yeah. That's most common. And that's the case, it goes outside the estate, and you don't have to probate that. It goes to them automatically. But you don't have to do it that way. It can be set up a number of different ways. And you can set it up within the trust to where if you want to guarantee that this property goes into another sort of entity. So the variations are almost endless. One
of the things, I know we're getting ready to go to break. One of the things I want to talk about, kind of put a pin on it as you would say, is I want to talk about how it can be dangerous if you don't plan like this and you allow things to flow through probate that shouldn't have gone through probate. You can run into a jam that you're going to pay creditors out of assets that you shouldn't have paid out of.
This is so good, so much good information. If you're like me at home, I learned so much in shows like this as you were learning about living trusts and wills on this show and how to really manage and distribute those assets in your family. So keep in mind, though, throughout the program, we're running information that you can get. Just pay attention and you'll see good information like you're getting from Bobby Lott and, of course, Josh Wright all the time. So we're going to take a break, but want to remind you to follow us on all the social media channels. Hollis, Wright, and Clay, the attorneys, is back right after this.
I'm Josh Wright with the law firm of Hollis Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys.
Did you know when you hire Hollis Wright, you are still in charge of your case? Our attorneys at Hollis Wright are client-centered, allowing you to help us control your case and result. At Hollis Wright, your result matters.
And we welcome you back to The Attorneys. If you've been with us throughout the show, then you know you've been getting some really good information about living trusts and wills. And as we come back to this segment of the show, we were going to break, and Josh, you talked about the importance of having a plan in place and the dangers of not having that.
Yeah, and I think it's an important point that Bobby, I think, can underscore a little bit for us, and that is if you don't have a plan, there are examples where certain assets that someone has can flow through the estate when they were supposed to be directed around the estate and be subject to creditors, which could be dangerous and could impact tax implications as well as really the viability of that asset if you have debt in the estate too.
Yeah, if you don't have a plan in place, then really bad things can happen. You can go from one extreme to where you have no plan whatsoever, no will, no nothing, and the laws of the state determine who gets what. If it's not set up correctly, creditors can get at your assets if there's some kind of judgment against you. But if you set up correctly, that you can prevent all that.
Mm-hmm. And it sounds to me like, you know, there are certain things that are beneficiary distributions, what I call beneficiary distributions, like life insurance generally is going to have a beneficiary. It flows outside the estate. It's not subject to debts that the decedent may have had. Another example would be 401ks or pension plans generally have beneficiaries that flow outside. And then we talked a little bit about homes, joint right of survivor, where at the time one spouse passes away, it immediately transfers to the other, doesn't dip into the estate and be subject to credit card bills or other debts of the decedent. And I mean, I think those beneficiary distributions are also super important.
Absolutely. And you can also, one good thing about a trust, with a will, let's say that you're left your parents or whoever's estate. You can't just take your will down to the bank and say, "Here, my dad named me as executive of his estate. Let me access the money." They won't do that. Yeah. You have to go through court. A judge has to get involved first. With a trust, you don't have to do that. You can skip that step. You can take most commonly have the trust already on file with the people that the assets have been transferred from the trust or into the trust. Excuse me. And so they already know that whenever you pass away, you automatically take over as handling their affairs. So it's much more efficient.
Talk just for a minute about when someone comes to you and says, "Look, I don't have an estate plan. I want an estate plan." What is the process you use and that you kind of walk through in order to be able to kind of advise them on what is the best way to create the estate plan for them?
That's a great question. And First of all, I sit down with them and we don't get in a big hurry about anything. And I'm not charging them from the immediate time we start talking. Find out what their situation is, what their goal is, what are they trying to accomplish. Do they need just a very simple estate plan? Or is it a situation where they do have significant assets and enough different things going on in their life that they might need a more detailed estate plan? Mm-hmm. And with the living trust especially, I try to demonstrate to them how much more, for most people, it's a much better option than just simple will.
But Bobby, you said you're not charging them when you first sit down with them.
Right.
But what are the costs involved? Is it an expensive outlay of funds in order to get that set up?
Well, the short answer is it depends. With a will, you can oftentimes get someone to do you a simple will for very minimal charge. The expense comes at the other end of life when you pass away and your heirs are having to open up an estate and pay the attorneys then it can get very expensive. With the trust, it's a little more expensive up front, but then all of your details have been taken care of. So when you do pass away, you don't have that expense of going to court. It's all been taken care of previously.
And do you talk about that? I mean, I know as lawyers, sometimes I'll get people that are like, well, when do I talk to you about the fee that you take on a contingency? And I'm like, oh, I'm ready to talk about that anytime. Like, we're flexible. We can make this work. How do you handle that? Because I know that's an issue. Like, do you generally do it hourly? Do you do it by project? Or do you just kind of communicate with the individual and make sure they understand what they're walking into from the start?
Yeah, it's always understood. We get that out of the way right up front. Most of the time, it's a flat fee, depending on what their situation is, how big the estate is, how many different assets they have, where they're located, et cetera. So I've done it long enough to be able to tell what's going to be the proper fee. Occasionally hourly. The hourly billing is getting a little bit out of fashion now. It's more efficient to do flat fees. But whatever the case, it's not going to be a case where you think the fee's going to be one thing and then you get hit at the end with something else. No, not at all.
And what I'm recognizing each time we do these shows, and Bobby's highlighting it, is you want to make sure you've got some plan, whatever the plan is. Even if it's sit down with someone for an initial consultation to ask general questions, to learn, it's worth that time. And it may just be that someone calls tonight and has a question and wants to talk to Bobby or talk just about estate planning. They've got a free, confidential opportunity to do that tonight.
And I think, Josh, that's the big takeaway, because we've been talking about a lot. This is a very complex situation, but very important that you get started on the front end and don't wait until later in the process. Bobby Lott, thank you very much. Josh, always a great time with you. And thank you so much for always joining us here on The Attorneys. And we want to remind you once again that number to call, 1-844 Law Talk. You can reach someone from Hollis, Wright, and Clay. It's free, it's confidential, and you can make that call right now. Make sure you join us for another edition of The Attorneys next week.
Thanks for watching The Attorneys, sponsored by Hollis Wright.